the Honorable Mai Maso Hewabi, touching upon historic allegations connected with the holder of the constitutional office of the Commissioner of Police. For the precision of the record, those 4 questions as placed were: Question 1, what is the current status of the allegations of rape against the Commissioner of Police, Mr. David Manning? Question 2, whether the Commissioner has been cleared of the allegation of rape. Question 3, Mr. Speaker, when will the Minister clear the good name of the police force from this allegation? And question 4, will the same Police Commissioner, Mr. David Manning, run the 2027 general election while this allegation of rape is still with him? Mr. Speaker, number 1, my guiding principles of this response. Mr. Speaker, this government and I personally as Minister are bound by and committed to the presumption of innocence, a principle entrenched in Section 37(4)(a) of our Constitution. No person, however high their office, stands convicted of an offence until convicted by a competent court of law. And that principle applies as much to the Commissioner of Police as to any citizen of this country. This government, Mr. Speaker, and I likewise affirm without qualification our respect for the separation of powers upon which our constitutional order depends. Parliament must legislate, the executive must govern according to law, and the courts must determine matters independently and without interference. The legitimacy of each arm is preserved when each confines itself to its proper constitutional function, Mr. Speaker. I take care in this response to observe the proper distinction between the office of the Commissioner of Police, established by Section 198 of the Constitution, and the person who from time to time holds this office. The Commissioner, Mr. David Manning, was reappointed in April of 2024, continues lawfully to hold the office, and is entitled to the same fundamental rights and protection as any other person. Number 2, Mr. Speaker, background to the allegations. Mr. Speaker, the matters referred to these questions are not new allegations awaiting examination. They are historical matters which have been repeatedly examined by the lawful institutions of the state over a period exceeding 2 decades, Mr. Speaker. The matter concerns an allegation, the substance of which was made in the year of 2000, some 26 years ago. The institutional record established through investigation and the inquiries that followed is that the underlying events arose from a lawful arrest carried out under a court-issued warrant by a unit under the Commissioner's command then, and that the allegations against the Commissioner were not corroborated by any available evidence. During the 26 years, Mr. Speaker, that have elapsed since that allegation, the matter has been subjected to extensive investigative, disciplinary, prosecutorial, and judicial scrutiny by the independent institutions exercising different statutory functions and responsibilities. The outcome of that scrutiny has been consistent. No evidence warranting charges has been identified. No court has made findings adverse against the Commissioner. No lawful process has produced an outcome adverse to his continued service as Commissioner of Police. Those are the formal outcomes. Taken together, Mr. Speaker, they represent extraordinary scrutiny over more than 2 decades. The outcome has been the same on every occasion. No investigator, prosecutor, disciplinary authority, or court has at any stage identified evidence capable of substantiating the allegation. The significance of the history is therefore not the allegations themselves, but the fact that they have repeatedly been considered by the institutions responsible for determining such matters and have repeatedly concluded without any advance finding against the Commissioner. That institutional record forms the proper background against which the questions before the House must be considered. The 4 questions and responses thereto, Mr. Speaker. Mr. Speaker, the first question, the current status of the allegation. To the question of the current status of the allegation, the candid answer is that it is no longer the subject of any active criminal prosecution, and no current judicial proceedings touch upon it. The investigation team assigned at the time of the allegation pursued all available avenues of inquiry. No witness, medical, or forensic evidence was identified capable of substantiating the allegation. The complainant refused medical examination and later provided materially inconsistent accounts, including a written recantation of the allegation. Mr. Speaker, that investigation was the subject of independent review by senior officers of the Royal Papua New Guinea Constabulary, who reached the same essential conclusion and expressed serious concerns regarding the credibility and evidentiary foundation of the allegation. It was then independently reviewed by the Office of the State Prosecutor based in Kimbe, who likewise concluded that the allegations was unsupported by evidence and that there was no proper basis upon which criminal proceedings should be commenced. In 2020, the complainant commenced civil proceedings in the National Court, styled as OS in brackets HR number 4 of 2020. Those proceedings were dismissed by the court for, amongst other reasons, want of prosecution. And Mr. Deputy Speaker, as members of this Honourable House will be aware, a want of prosecution is a failure by a plaintiff to progress a matter or proper evidence in support to their claims. In 2024, further proceedings were commenced, styled OS number 59 of 2024, seeking in substance to relitigate the same matters. The National Court dismissed the proceedings in their entirety as an abuse of process of the court and referred the legal practitioner for the plaintiffs to the Papua New Guinea Law Society for inquiry into possible breaches of the Professional Conduct Rules of 1989. No finding adverse to the Commissioner was made. The complainant's most recent of many varying reports was against re-agitated in 2024 following dismissal of court proceedings. As in previous instance, no corroborating evidence was adduced. Such matters are appropriately the remit of investigative agencies being a constitutional institution acting independently of the executive and run the proper course on the basis of evidence or lack thereof. In short, the matter is historic in origin and has been determined to be without corroboration or evidence on every occasion of examination. The present status of the matter is therefore not one of unresolved institutional uncertainty. Rather, it is a matter that has been repeatedly considered by the appropriate institutions of the state with consistent outcomes on each occasion. Mr. Deputy Speaker, it is the responsibility of the Minister to be candid with the House about the institutional position as it now stands. The factual record is neither new nor uncertain. What is remarkable, Mr. Deputy Speaker, is not the allegation itself, but the extraordinary number of occasions upon which it has been examined and rejected by the institutions lawfully entrusted with that responsibility. Over a period of 2 decades, the matters have been subjected to investigative, disciplinary, prosecutorial and judicial scrutiny by different institutions exercising different powers under different statutory frameworks and for different purposes. The outcome has been consistent. The allegations have repeatedly been placed before the institutions of the state responsible for considering them. Those institutions have performed their functions, investigations, and have been conducted. Reviews have been undertaken. Prosecutorial consideration has occurred. Judicial proceedings have been commenced and concluded. No criminal conviction has resulted. No court has made finding advance against the Commissioner. No lawful process has produced an outcome adverse to the Commissioner's continued service as a member of the Royal Papua New Guinea Constabulary or subsequently as Commissioner of Police. Mr. Speaker, 3 matters bear noting. Number 1, first, both instances in which the courts considered and dismissed proceedings related to this matter, namely 27 February 2023 and 13 April 2024, were civil proceedings which bear substantially lower burden of proof than a criminal proceeding. Notwithstanding the lower burden before the plaintiffs, the court dismissed these matters, the first for want of prosecution, the second as an abuse of the process of the court. Number 2, secondly, over a period of some 26 years, an extensive range of independent processes have been examined the substance of this allegation, including most recently in 2024. No evidence in support of the allegation has been identified by any institution of state over a period of 26 years. Thirdly, Mr. Speaker, the conclusions reached in 2000 have been independently confirmed on multiple subsequent occasions. The consistency of those conclusions reached by different decision makers under different procedural frameworks is a matter to which the House is entitled to give weight. Mr. Speaker, I come to the second question, whether the Commissioner has been cleared. The second question is in some respects the most demanding to answer because the word cleared carries different meaning in different contexts. In a strict criminal law sense, a person is probably described as having been cleared where there is a verdict of not guilty. A discontinuance of charges or a formal closure of investigation with a determination that no charges will be laid. As I have detailed in my response, the investigation of this matter some 26 years ago determined that the investigation be formally closed with a determination that no evidence existed to warrant criminal charge. In an administrative sense, the finding of not proven entered in connection with disciplinary investigations in 2000, as stood as the disciplinary disposition of the matter for more than 2 decades, reflecting that even when considered with less stringent evidentiary rules, no evidence to corroborate the allegation was identified. In a civil law sense, both sets of proceedings before the National Court have been disposed of in the Commissioner's favour, the most recent as an abuse of the process of the Court. The honest answer accordingly is this, Mr. Deputy Speaker. At the time of the allegation, no evidence was identified to warrant criminal processes. At the time of independent review, no evidence was identified. At the time of administrative investigation, no evidence was identified. At the time of civil proceedings, no finding adverse to the Commissioner was made. Mr. Deputy Speaker, the Commissioner is entitled to the full benefit of the presumption of innocence, and this government will at all times defend that principle. On every occasion the allegation has been examined by a lawful institution of the state, the conclusion reached has been consistent with the Commissioner's position. This institutional record, Mr. Deputy Speaker, speaks for itself. Mr. Deputy Speaker, the Commissioner's subsequent career speaks equally clearly. Following those events, he continued to serve Papua New Guinea with distinction, was entrusted with positions of increasing responsibility, and ultimately appointed Commissioner of Police. Those entrusted with responsibility for assessing leadership, integrity, performance, and suitability for high office repeatedly found him worthy of that trust. Question 3. Restoring the good name of the police force. Mr. Deputy Speaker, I take the question in the spirit in which I believe it was put. I must, however, respectfully observe 2 matters. First, the good name of the force does not rest on the conduct, character, or reputation of any single officer. It rests upon the daily service of the thousands of women and men who, in their often challenging circumstances and at risk to their lives, uphold the law throughout the length and breadth of our country. Secondly, Mr. Deputy Speaker, it is not within the gift of the Minister or of any Minister to clear the force in the manner the question implies. The institutional health and reputation of the force is built through proper investigation, fair process, accountable command, and through the lawful institutions that supervise it. It is not built upon parliamentary declarations or insinuations, Mr. Deputy Speaker. Mr. Speaker, when this Minister will continue to Mr. Deputy Speaker, what this or myself as Minister will continue to do is to ensure that the institutional infrastructure within which the force operates is robust. The government remains committed to the continued professionalization of the force, has committed substantial budgetary resources to its modernization and to the welfare of its personnel, and continues to engage with the Constitutional and Law Reform Commission on the revision of the Police Act 1998. The good name of the Royal Papua New Guinea Constabulary is reflected in the daily service of its officers, the strength of its institutions, and in the quality of its leadership. Mr. Speaker, the record demonstrates that the institutions of the state have performed their functions. The Commissioner continues to service lawfully in his office. The force continues to serve the people of Papua New Guinea. The government has every confidence in the integrity of the Royal Papua New Guinea Constabulary and in the men and women who serve within it. Question number 4, Mr. Speaker, the Commissioner in the 2027 general elections. To the first element of the question, the Commissioner was lawfully appointed by the Head of State, acting on the advice of the National Executive Council in April 2024 for a term of 4 years. His tenure is governed by the Constitution, by the Police Act 1998, and by the contract of appointment, and the grounds upon which the appointment may be vacated are exhaustively prescribed by Section 9(5) of the Police Act. The government anticipates no disturbance to his tenure before it expires in the ordinary course, and he continues to enjoy the full confidence of the government in the discharge of his constitutional and statutory duties. To the second element, the integrity of the 2027 general elections, I give this Honourable House this absolute assurance. The Marape Rosso government's commitment to a free, fair, credible and peaceful 2027 general elections is unwavering. The Royal Papua New Guinea Constabulary will discharge its electoral security responsibility with the professionalism for which the force has been recognised over many electoral cycles. Mr. Deputy Speaker, the Commissioner is not approaching these responsibilities for the first time. He has already led the Royal Papua New Guinea Constabulary through periods of significant national importance, including the conduct of national elections and associated security operations. His experience, leadership and service record are well known to this House. He has already successfully led the Royal Papua New Guinea Constabulary through 2 national elections and the substantial security operations associated with those elections. There is no serving officer with greater experience in the planning, coordination and delivery of election security operations at the national level. The government therefore has every confidence that the Constabulary, under his leadership, will continue to discharge its constitutional responsibilities in support of a free, fair and peaceful general election in 2027. The response of the Marape Rosso government. First, the government respects the institutional independence of the courts, the Office of the Public Prosecutor, the Ombudsman Commission and the other bodies that have considered these matters. It will not, through political process, seek to supplant the conclusions properly reached through lawful processes. Those institutions are permitted to perform their functions independently. Investigations have been conducted, reviews have been undertaken, prosecutorial assessments have been made, judicial proceedings have commenced and concluded. The government accepts and respects the outcomes of those lawful processes. Secondly, the government affirms its confidence in the constitutional and legal framework by which these matters have been considered. The rule of law requires that allegations be capable of investigation and scrutiny. It equally requires that the outcomes of lawful institutional processes be respected once those processes have run their course. In this matter, the institutional record is extensive, long-standing and clear. The allegations have been repeatedly examined by the institutions entrusted with responsibility for considering them. Mr. Speaker, the process has consistently concluded without any finding adverse to the Commissioner. The government will therefore continue to support the integrity of the institutions of the state, the proper administrations of justice, and the continued leadership of the Royal Papua New Guinea Constabulary in service of the people of Papua New Guinea. A word concerning the Commissioner of Police. The government has every confidence that the Commissioner will continue to discharge the operational responsibilities of his office with the diligence and professionalism which have characterized his service to date. The Commissioner has dedicated the greater part of his professional life to the service of Papua New Guinea. Throughout that service, he has been entrusted with responsibilities of increasing importance, including some of the most demanding operational and leadership roles within the Royal Papua New Guinea Constabulary. He has led the Constabulary through periods of significant national importance, including major security operations and 2 national elections. His experience, professionalism, leadership and commitment to public service are well known throughout Papua New Guinea. The government's confidence in the Commissioner is founded not upon words, but upon a record of service, performance and leadership established over many years. The Commissioner has earned that confidence through service, through experience, and through a record that has been tested repeatedly over many years. The Parliament, the rule of law, and the privilege of this House. Parliamentary privilege conferred by the Parliamentary Powers and Privileges Act, Chapter 24, is among the most important protection afforded to this Honourable House. It exists to ensure that members may speak freely in the discharge of their duties and in the service of Papua New Guinea. That privilege carries with it a corresponding responsibility. It must not be used as a vehicle for the re-litigation on the floor of this House of matters already determined by the lawful institutions of the state. The institutions of the state exist for that purpose. Courts determine disputes. Investigators investigate. Prosecutors assess evidence. Disciplinary bodies exercise their statutory functions. Parliament, in turn, performs its own constitutional role. The strength of our democratic system lies in each institution respecting the role of the other. The government, Mr. Speaker, the government's position is that the integrity of those processes and institutions that undertake them should be respected. And in conclusion, Mr. Speaker, conclusion number one, the allegations are historical over a period preceding 2 decades that have been subjected to investigative, disciplinary, prosecutorial and judicial scrutiny by the institutions lawfully entrusted with responsibility for examining such matters. The resulting institutional record is extensive, long-standing and clear. The allegations have been repeatedly examined through lawful processes, and no institution has produced a finding adverse to the Commissioner. Conclusion 2, the Commissioner of Police continues lawfully to hold office and is entitled to the full protection of the presumption of innocence. The government's position, founded on the institutional record and the constitutional framework, will continue to respect the integrity of the lawful institutions of the state. Conclusion 3, the government will continue to uphold the rule of law, respect the integrity of lawful institution processes, and support the continued service of those entrusted with protecting the people and constitutional order of Papua New Guinea. Thank you, Mr. Speaker.